This is an appeal in the matter of the Secretary of State for WAC and Pensions and NJ.
Yes, good morning.
Good morning, my ladies, my lord. I appear for the Secretary of State with Mr. Edwards and Mr. Matt Jackson, Mr. Daniel Hallstrom appear for the respondent.
Before you get going, I'm sorry to interrupt, Ms. Hyde. Can I just ask, have you had a chance to discuss how long you estimate your submission is going to last, please?
We haven't, but I don't think we're going to have any problem with time.
Right.
Which is why we haven't discussed it.
We've read, obviously, both decisions with some care, and we've read the skeleton arguments, so you can tailor your submissions accordingly.
Will do, and
Thank you.
obviously if I'm going on unnecessarily, I'm sure the court can let me know.
I'm sure it won't be unnecessary.
Can I just check that the court's got 3 bundles, a core bundle, a supplementary bundle and an authorities bundle? And just to check the court has the right authorities bundle, tab 16 should be the ICR version of Uber, and that means that the court then has the right bundle. There are some other tweaks, I think, as well, but yes, very grateful. I've also just been asked to remind everybody in court that there is an anonymity order in this case.
Right.
We'll obviously all be very careful, but I understand that the live feed is on a delay. Should anybody inadvertently read something out or say a
Right.
name.
Well, thank you for reminding us about that.
So I'm basically proposing to take the following structure. I'm going to start by looking at the facts by reference to the first tier decision, then to go straight into our position on the meaning of the legislation, and then finally to go to the Upper Tribunal's decision and go through it, basically saying why our grounds of appeal are right. Could I just make a point at the outset before I start that essentially our case is that the Upper Tribunal erred in its construction of the regulation, and it's simply not capable of being met on the facts of this case. So this isn't a challenge to factual findings, and nor does our case rely on any evidence. It's simply, apart from ground 3, about the proper interpretation of the legislation and its application in this case. Paragraphs 14 to 18 of our skeleton set out the facts. I will be referring to our skeleton a few times if it would help the court to have that out separately. It's in the core bundle at page 21, tab 3, if the court has tabs. And then, just so that the court has the right place in the bundle for the decisions, the Secretary of State's decisions, which were appealed to the tribunals, are decisions of that the original decisions are dated the 8th of October 2019, the 4th of February 2020, and they are at tab 16 of the core bundle at pages 150 and 151. And then what happens is that there are 2 mandatory reconsideration decisions, and those are the decisions which then lead to the appeal, and those are to be found at page 153 and 162 of the core bundle. And just briefly to show the court a passage in one of those decisions at page 154, by the bottom hole punch on page 154, the Secretary of State says, while I fully appreciate the benefits of sunlight and ecotherapy upon your health condition, this appears to be more of a therapeutic benefit rather than actual medical treatment carried out by a person qualified to carry out said medical treatment.
Sorry, where are you reading from?
And that's page 154, bottom hole punch.
Thank you.
I'd obviously invite the court to look at the whole of the letter, but just to pick up on that passage, and then over the page 155, immediately below the bottom hole punch, whilst I can appreciate that the warmer climate may help your condition, you've provided no evidence that your travel abroad is solely to receive pre-arranged medical treatment. So that's really a shorthand for the submissions that we've made in writing and I'll be making orally. And And then just to start with the first tier's decision, essentially because this is where the relevant findings of fact are, and that's at tab 15, core bundle, page 140. So beginning with paragraph 13 on page 151, there's no dispute about the dates referred to in the decisions or the dates the appellant is said to have been absent from Great Britain. Paragraph 16 and 17, the court may have seen that the tribunal makes an express finding that both witnesses were honest and credible. And then
Who gave evidence? Just remind me, it was the appellant
both
and the
of them,
husband. Both of them.
yes. The appellant and her husband. And then paragraph 18, the findings that result from that evidence, just to pick it up at paragraph E on page 143, which is a brief history of treatment, and what that says is that there was a referral to a psychiatrist and then later a referral to a clinical psychiatrist that then led to disclosure of the severity of the symptoms, and then seen by counsellors, nurses and occupational health practitioners prescribed medication. Paragraph G addresses the fact that the property has been owned since 1987, purchased in around 2001, habitable building around 2012. And then paragraph H says that the couple first went to stay in 2012, and then it was during this trip by coincidence that they noticed a marked improvement. So this begins with the noticing of a marked improvement. That marked improvement leads both of them, and I emphasise both of them, to undertake research into what may have caused the improvement and came upon the benefits of sunlight. And we would say that plainly researching the benefits of sunlight is something which anybody could do, and indeed many people do research in relation to things that may help medical conditions that they have. Then we see at paragraph I the appellant's husband's history, and that he took early retirement after realising that his wife was at crisis point, that he retires to support her with managing her condition. Obviously there's no suggestion that the support has anything to do with any treatment at all, it's simply helping her to manage her condition. He remains on the register, but he's no longer licensed. And then we see at paragraph J that the first tier refers to Dr. J undertaking extensive research. We know that his wife had also done some research from H. And then we see that both attend a national conference in 2013 where they attend lectures and began to understand the link between sunlight and OCD. And then we see there a letter from the GP who refers to what the appellant has reported to him and then said this seems scientifically plausible and quite reasonable from my point of view. And then we see that the appellant and her husband are adamant about the benefits of sunlight and the particular climate, and we accept that. And then we see what happens, what the couple do in Almeria. I'm not sure if I'm pronouncing that correctly. That's described at E. The point that we take from E is this: 4 lines down, whilst Dr. J does attend to his own chores and jobs around the property, he's never far from the appellant's side and will supervise, for example, if she's longer in the bathroom than he might anticipate. He's aware this may be a result of water having triggered the appellant's OCD and will assist in calming her. Nowhere in this decision will you see any reference to him supervising sunlight. What he's doing is helping her, as he does at home, deal with the consequences of her condition, completely understandably. And then paragraph N, there's a reference to not being able to go during COVID, and that the couple thinking that exacerbated the situation. And then just to feed through in the reason section does deal with the facts. at paragraph 21, the first tier says the sole reason, and this is just by the top hole punch, the sole reason for the appellant Dr. J going to Almeria for extended periods of time, note the reference there to going for extended periods of time, is in order for her to access sunlight and the unusual climate Almeria offers. The couple do not go on other holidays, and their time spent in Almeria is simple and somewhat uncomfortable. I accept the appellant's evidence that this wouldn't be a choice of holiday. Accordingly, I accept that the absence is solely. So what the first tier has done, as the Upper Tribunal also did, is direct itself that the question is what were the reasons for extended absence, as opposed to what were the reasons for the entirety of the absence. And then paragraph 22, the first tier concludes that exposure to sunlight meets the definition of treatment. We say that's fundamentally a legal question, so I'm not going to deal with it now under facts. And then we get another mention at paragraph 23 of them both noticing an improvement in her symptoms. And then the first tier accepting their evidence about the improvement that they both noticed. So if, contrary to our case, this were capable of being treatment, it's something they've just noticed that's good, a good thing, both of them. It's not what one would expect from treatment, which is a clinician saying, I advise that you do this or I'm going to do that. And for reasons I'll come to, in this particular case, it's more about a clinician doing rather than advising, and I'll come on to that when I deal with the law. Some further factual matters referred to in paragraph 28. Dr. J knows his wife, and thus the impact and severity of her condition better than any treating psychiatrist would. Further, as he is himself medically qualified, he has the necessary transferable skill to be able to conduct research and acquire knowledge in relation to the specific disablement which his wife suffers. I accepted his evidence as to the supervisory role while the couple are in Almeria. Well, I've shown the court that the supervisory role is in respect of the condition rather than any treatment, because what the first tier accepts is a paragraph 18I, and that's about supervising her, helping her with her condition. The second thing is that the first tier refers to him having transferable skills to conduct research and acquire knowledge, but we've seen that the appellant has also researched herself, and as I said at the beginning, it's really the sort of research that anyone could do. The only difference between this couple and another couple would be if the other couple didn't have a medic on hand in the family that they could call on. And as I said earlier, many people research things that might be beneficial for particular conditions they have, including sunlight, but that doesn't make it treatment. And then finally, paragraph 31, we can again see what the first tier tribunal is finding. So paragraph 31, it says this: I'm satisfied this is not a case of a couple simply spending time holidaying in their second home. And we say that word simply is significant because what the tribunal has done is direct itself, is that it's the reasons for extended absence that matter. So what it's saying effectively is, well, they are spending time holidaying in their second home, but that's not all they're doing. The reasons for the extended absence are because of the benefits of sunlight. We say that it's that second bit that's effectively a misdirection, but the finding is they're not simply doing it, but that indicates that they're doing it for two reasons. If you look at the whole of the period of absence, and I'll come back to that point.
So in other words, it undercuts the finding that it's solely for the purpose.
Exactly.
Yeah.
And then the
It's
same
a bit ambiguous, because I spent a bit of time with that, because I didn't read it like you suggested. To my eye, it's a bit ambiguous what the tribunal is saying, but I think, speaking for myself, I completely take the point about the extended leave.
Yes.
But what they meant here is a bit less clear.
yes,
You can read too much into it.
no, that's fair. I think the final line though, we could say when you read the whole thing, you look at the direction it gave itself about extended periods of absence, and then the reference in the last line, and for that specific reason they seek to spend extended periods of time there. the first tier is clearly saying it's about the extended periods, and indeed the couple have been going to this home since 2012. It would have been a very odd finding. Indeed, under ground 3, which we say doesn't arise, we would say it would be perverse to find in these circumstances it was the sole purpose. But our case is, in any event, the first tier and the upper tribunal applied the wrong test. It's about looking at the purpose for the whole of the absence.
Was the first-tier tribunal using the term extended to distinguish it in this particular case, having regard to the purpose of Regulation 153 as against 152, the short absence?
It was, my lord, but we say that involved impermissible mixing and matching of the two, and I'll come on to that. I'll come on to that now. So that was all I proposed to say about the facts. I was then going to move on to interpretation of the legislation. I've handed up a slightly easier to read and more fulsome copy of the relevant bit of the 2008 regs, because I don't think the court had some of these provisions, and we thought it would be helpful to see 153 in context. So I'll be coming on to that in a moment, but I wanted to start with the enabling provisions. So putting away the core bundle for now, and we won't need it again until the third bit of my submissions, hopefully. Turning to tab 1 of the authorities bundle and section 1 of the Welfare Reform Act 2007, that's tab 1, page 3. So this is the act that establishes an Employment and Support Allowance in 2007. It's a new benefit, and it provides that it's payable in accordance with the provisions of this part of at 1.1, and then the claimant in 2 has to meet the basic conditions and then some additional conditions, and then the basic conditions are set out at 3. The basic conditions are that the claimant is entitled to be in employment and so on, and then D is in Great Britain. Now, being in Great Britain, there is further provision about that in regulations not relevant to this case. For example, it prescribes circumstances in which a person is to be treated as being in or not being in Great Britain. So an example of that might be somebody who doesn't have a right to reside. I know my Lady Justice Whipple.
We've been there before.
That. We have, yes. So that's that provision, and there is then at tab 2 a specific provision about disqualification for being absent. So that's on page 5 of the authorities bundle. And Parliament provides at 18.4, and there's a blue line, except where regulations otherwise provide, a person shall be disqualified for receiving a contributory allowance and employment and support allowance in brackets. I'll come back to why that's in brackets, for any period during which he is absent from Great Britain. So Parliament says you can't have it when you're abroad, save to the extent that regulations provide otherwise. The reason that employment and support allowance is in brackets is because going forward, claimants will only be able to receive contributory ESA because others are being transitioned onto universal credit. That's the only reason for that, but the court doesn't need to worry about that for present purposes. The point is you're disqualified for any period during which you're absent. So that makes it important in our submission to look at the terms of the regulations with some care. So could I then invite the court to look at the clip that I've handed up? We have some extracts in tab 3, and I will be using that as well, but this clip has got the beginning provision, which is Regulation 151.
I'm so sorry to interrupt. So it doesn't look as though we've got the provision that authorises the making of these regulations.
As I understand it, but I'll turn my back, it is Regulation 18.4.
Right, and presumably there's a provision somewhere else in the Welfare Reform Act about, which tells you which procedure the regulation is, whether it's
Yes, I'm sure there is, and we can find that out. There is also provision, and it's in, I think, possibly in Schedule 2, providing that regulations may provide when somebody is or is not to be treated as being in Great Britain. But that's used for a different purpose effectively. But we'll apologies, we'll make sure we provide the court with that. And then 151, ignore 1A because that wasn't in force at the material time. On the Westlaw clip that I've handed up, 1511, compatibly with section 18.4, says a claimant who's entitled to an employment and support allowance is to continue to be so entitled during the period of temporary absence from Great Britain, only in accordance with this chapter.
So that tallies with 18.4,
It does,
does it?
yes.
Yeah.
And then regulation 152 says this: a claimant is to continue to be entitled to an employment and support allowance during the first 4 weeks of a temporary absence from Great Britain if the period of absence is unlikely to exceed 52 weeks and while absent from Great Britain the claimant continues to satisfy the other conditions of entitlement to that employment and support allowance. So that is a specific and bespoke provision in relation to the first 4 weeks of a temporary absence if the period of absence is unlikely to exceed 52. So it envisages that 4 weeks being part of a longer absence. What it doesn't do is envisage that 4 weeks being part of a medical treatment absence. And then regulation 153, the writing's bigger in the version I've handed up, but it's also available in the authority bundle at tab 3, page 13. Could I just shut up for a moment and just invite the court to read regulation 153 and then I'll make submissions about it, including the heading. So the first point that I would make, and it's an obvious one, is that statutory provisions need to be read as a whole and in context. So although I'm going to now break it down into different bits, we accept that's an artificial exercise. Nonetheless, it's necessary to do that, to look at the various different words which are used. And we say, when you look at all the different bits and read them as a whole, the answer to this case is clear. So I'm now going to embark on that somewhat artificial exercise of looking at different bits. Can I start with the heading, which is absence to receive medical treatment? So 2 points. It's to receive medical treatment, and it refers to medical treatment rather than any other kind of treatment. Now, I accept, and I'll show the court why, we accept it's more than only medical treatment, but we do say that the heading gives the first hint that what's included is narrow. The next point then is to look at 1531. A claimant is to be entitled to an employment and support allowance during the first 26 weeks of a temporary absence from Great Britain, if, and then we get the conditions. So we say those words, during the first 26 weeks of a temporary absence, are important and are clear. What they are doing is looking at the whole of the first 26 weeks. They're not looking at the second full 26 week. They're looking at during the first 26 weeks of a temporary absence, and we say just on its own that makes good our point about what the statutory question is. When that's then read in conjunction with the conditions in 1531, it becomes all the more clear. So during the first 26 weeks of a temporary absence, if the period of absence is unlikely to exceed 52 weeks. So again, what you've got is both 152 and 153 looking at 52 weeks, but one of them looks at the first 4 weeks and one of them looks at the first 26 weeks. But they can't be mixed and matched, we say. The other important point that we draw from C is, of course, the use of the word solely, which does not appear in surrounding provisions that I'll come to in a moment. So solely, and the Upper Tribunal rightly observes that that was a tightening of the conditions to get benefit when getting treatment abroad. And it's solely in connection with arrangements made for the treatment of the claimant, and the bits that follow tell us more about the treatment. So, read with 1531, we say the condition has to be satisfied for the entirety of the absence. There's nothing to say it's subject to an initial 4-week period for an unrelated absence. The words in connection with plainly don't modify the effect of the word solely. And of course we accept that treatment isn't the only thing you can be doing once you're there. You're not required to stay in wherever you're being treated and not do anything else. You'll obviously go out for dinner and so on, but that's a different point. And I'll deal with that when we get to the Upper Tribunal's decision. So turning then to the words of Regulation 1531D, 3 requirements: that the arrangements relate to treatment outside Great Britain during the period whilst the claimant is temporarily absent from Great Britain, and by or under the supervision of a person appropriately qualified to carry out that treatment. We say there's a lot packed in there, so can I make 5 points on Regulation subparagraph, I think it is, D. So the first point is that it involves, I'll use that loosely at the moment, an appropriately qualified person, so you can't treat yourself at a very high level. The second point is, what is that person doing? They're either carrying out your treatment or they're supervising treatment being carried out. So it isn't enough if the person is simply helping you manage a particular condition. It has to be, they have to be carrying out treatment or supervising treatment being carried out. That then takes me to the third point, which is that carrying out is the language used, and that we say is active rather than passive. So as we say in our skeleton, there's an obvious issue about whether receiving sunlight is capable of qualifying because it exists in nature. It's not something that is carried out. And see the next provision which refers to treatment being provided, nor is it something which is provided. Nor is being in sunlight something which requires supervision. Still less does it require supervision by an appropriately qualified person. So there's all sorts of reasons we say if that wording is looked at as a composite part, that it's the carrying out of treatment by a person, or an appropriately qualified person is supervising the treatment being carried out, but at all times there is treatment being carried out. The fourth point we make, and this comes from D limbs 1 and 2, is that the treatment has to be outside Great Britain. It's not enough that there's treatment in Great Britain, because the language is very specific. These arrangements relate to treatment outside Great Britain during the period while the claimant is temporarily absent. And that's important in this case because it's necessary when one comes to look at the Upper Tribunal decision to say, well, what actually was the treatment here? Was it researching sunlight? That all happened in the UK. And then the fifth and final point to make on that specific provision is that in our skeleton at paragraphs 33 to 35, we've set out the department's position on what does appropriately qualified mean. Now, of course, what we're talking about is treatment in another country, as we've just seen. So the Secretary of State can't use similar language to, say, a healthcare professional registered in this country because the person's out of the country. So that's one reason for saying appropriately qualified. We also say that word appropriate is directing that it depends on the nature of the treatment and the qualifications of the person. So some treatment will require a doctor, other treatment might require a physiotherapist if it's physiotherapy, some might require expert treatment, and we say that about novel treatments for mental health conditions, see our skeleton. What we do say, although we say it doesn't get to this for other reasons, but we do say that a colorectal expert is not appropriately qualified within the meaning of D3 to prescribe treatment for OCD. But in fact, the case doesn't fall for that reason, it falls for other reasons. It's just another reason. So that's the
Are you going to deal with the fact that he's also retired?
Yes, what I'm going to do is when we get to the Upper Tribunal decision, I'll deal with the specifics as it relates to this case, because there's some discussion there, and some of what the Upper Tribunal says we accept is right, some of it we say it's wrong, of course. Yeah. Regulation 1531 D. I mean Regulation 1532, because I've just dealt with D. What this does is define appropriately qualified, and we say this now gives us more information about the permissible forms of treatment, reading it as a whole. So what it says is, appropriately qualified means qualified to provide medical treatment, physiotherapy, or a form of treatment which is similar to or related to either of those forms of treatment. So two things we say about Regulation 1532. The first is that through this definition it's telling us what forms of treatment are included, and we say that is narrow, actually. It's medical treatment, we've seen that from the heading, but it adds on physiotherapy, and then it adds on or a form of treatment which is similar to or related to either of those forms of treatment. So we say that's a narrow definition. When Early Friend made the point in his skeleton that an aromatherapist would be covered, we say absolutely not. That's not medical treatment, that's not physiotherapy, and neither is it similar to or related to. The second point we make, and it's similar to the point I made about carried out, is here it refers to providing of treatment. So treatment is something which is provided or carried out by a medically qualified professional or appropriately qualified. Now, just to make a point perhaps about physiotherapy to show how it might work, clearly if somebody said, oh, I know an excellent physiotherapist in France and I'm going abroad just to say them, the point might be made, well, solely? Aren't there some very good physiotherapists in London? But one can see a case where, for example, somebody goes abroad for surgery for a broken bone, and then when that surgery is done, continues in France because they're having physiotherapy. So it makes sense that physiotherapy would be included, but it's a narrow definition, we say. So that then leads to the question, well, we know what physiotherapy is, what's medical treatment? And for that, we need to look at the definition in Regulation 2. That's in the same tab, it's at page 8. So just below the bottom hole punch, medical treatment means medical, surgical or rehabilitative treatment, including any course or diet or other regimen, I'll come back to that, and references to a person receiving or submitting to medical treatment are to be construed accordingly. Now, I'm going to show the court in a moment the Slabbing case, where the court looked at what medical treatment meant in that context. We say surgical treatment is obviously very specific. As to the reference to the words in brackets rehabilitative, including any course or diet or other regimen, we say there that the words regimen are limiting words. It's assuming that a course or a diet is a regimen, so that's in a sense the umbrella term. We say that the word regimen, just in natural language, means some kind of structured plan prescribed, I don't mean in the sense of medication, but prescribed by a health professional.
Does it also mean as part of your rehabilitation? So, for example, if you've had surgery,
Yes.
or you may be in an accident or something, and you need to get back on track, you could have a regime of physio post-surgery, and they might want to build up your muscles, so they might say, well, eat particular types of food.
Yes, exactly. But it's exactly that. But it's a regimen. It's not an idea that something is helpful.
Yeah.
However powerful, one accepts that it's powerful. However powerfully something may be helpful, that's not a regimen. There's no here. Nobody said, well, you go there and be in the sun between these particular times and do this and do that. That there isn't sunlight doesn't lend itself to the word regimen. And we agree, it's precisely that sort of situation that would be addressed. And of course, I remind the court that this definition of medical treatment applies elsewhere. In the specific context of Regulation 153, it's limited because remember that the treatment has to be carried out or provided. So it's in theory something could fall within the definition of medical treatment, but not be carried out or provided abroad, and so then it wouldn't qualify. And of course, there's a reference there to receiving or submitting to medical treatment. Although we don't have those words in 153, we say it's really the flip side of treatment being carried out or provided. The medical professional is active, the person being treated is receiving treatment or submitting to it.
So in other words, it's passive.
Yes, passive, exactly. The person is passive, but that's because somebody in the other country is carrying out actual treatment. And then just for completeness, there is a definition of healthcare professional on the other side of the page between the hole punches. That doesn't appear in Regulation 153. The reason that's there is because it relates to provisions which say that somebody can be called to an examination to determine their capability for work and work-related activity. But we say, in fact, when you look at the term appropriately qualified, you're looking at what's appropriate in the circumstances, remembering that it's about treatment being carried out abroad.
So healthcare professional is not a phrase that's used in
No,
the provisions we're concerned with, so the definition of healthcare professional is irrelevant.
exactly, yes. We haven't referred to it, my friend refers to it, but it is irrelevant. In fact, it's not used, and instead appropriately qualified is used. We say A shows that a different approach applies, and B is because the treatment has to be carried out in another country.
Yeah.
So that's broadly what we say about the provisions. Before I go to the authorities, could I just show the court the surrounding provisions? Again, we say this is significant part of the context. So in the Westlaw clip, the court has regulation 154. And this is about absence to receive NHS treatment. So essentially this is going abroad for NHS funded treatment. And notice that the period here is any period of temporary absence from Great Britain, and there is no solely. So this is specific. It's for the purpose C154B of the claimant receiving treatment at a hospital or other institution outside Great Britain where the treatment is being provided, and then under those provisions. Again, all of these provisions are in their own silos, in fact. They're discrete provisions, each covering their own territory. And then regulation 155, again, any period of temporary absence, and that is being a member of Her Majesty's Forces. No solely in that provision. Now, I mentioned to the court that there are other references to medical treatment. So in our case, there are, in regulation 153, there are the limiting words in 1532, but just to show the court where else it crops up. Regulation 157, which is on page 17, this is disqualification for misconduct. And that 1571B, if somebody fails without good cause to attend for or submit to medical or other treatment, excluding vaccination, inoculation or major surgery recommended by a doctor. So, in other words, if you're prolonging your own medical condition. Notice there that there's a reference to medical treatment and then other treatment. And we say that's broader than what's encompassed by 153 because of the limiting words in 1532. And then Schedule 6, which is over the page, this relates to situations where somebody's temporarily absent from their home. And this has two provisions. So at the bottom,
Right,
page
lost track.
20,
Where are we? Page.
Schedule 6 begins on page 19. So this is about circumstances in which a person is to be treated as occupying a dwelling as the home. And then 11 is a clause which says that where a claimant is absent from a dwelling that they normally occupy as a home is temporary and one of these other conditions are met. They're to be treated, C12, as occupying the dwelling during any period of absence not exceeding 52 weeks. So, two provisions I wanted to show the court here, again broader than our provision. So the first, on page 21, top hole punch, one of the conditions is that that claimant is C, and then 3, undergoing, or as the case may be, that claimant's partner or dependent child is undergoing, in the UK or elsewhere, medical treatment or medically approved convalescence. So that again is something different. Convalescence in accommodation other than residential accommodation. And
It's
then
a bit like the cruise case.
yes, so we're going to that.
Good.
It's too fun not to. And then C6, undertaking the care of a child whose parent or guardian is temporarily absent from the dwelling, normally occupied by that parent or guardian, for the purpose of receiving medically approved care or medical treatment. And we say that's an important distinction between care for a condition, and we say that is what the appellant's husband was doing in Spain, or medical treatment. So the legislation contrasts those two things. They're not the same, and the Upper Tribunal does actually, we say, rightly accept that. But there is no absence to going, there is no reference, to going abroad to receive medically approved care in our provision. It's more narrow.
So just to orientate us, you're taking us to these points to illustrate the point that the provisions of Regulation 153 are materially different from, and using language which is different from, the other parts of the regulations which contemplate different types of provision of care.
Precisely so, my lord, and I show that Regulation 153 is narrow and should be interpreted as we say. These are simply points of context, but obviously that's relevant to the statutory construction exercise.
Thank you.
So turning then to the authorities, and sorry, we need to postpone gratification and start with the Slavin case at tab 14. So this is a decision of this court. I accept different legislative wording, and I also accept that the Upper Tribunal wasn't referred to this authority. Nonetheless, I say that this court does need to see it. So we summarise this just for the court to note in our skeleton at paragraph 40. Could I just invite the court to read paragraph 1, which summarises the issue? So this is a care home, not a nursing home, and the court proceeds on the basis that the staff don't have any medical or nursing qualifications, and the issue is whether the claimant is maintained free of charge while undergoing medical or other treatment as an inpatient in a hospital or similar institution within the meaning of Regulation 12A. Now, we accept entirely that in our case we don't have the words as an inpatient in a hospital, but the court isn't particularly swayed by those words. As we'll see from the judgments, it's looking at the definition of medical or other treatment and what that means. And then just to look at the facts, two points to draw to the court's attention in the facts. In paragraph 2 of B, this is somebody whose behaviour was extremely challenging, such that he needs to be continuously supervised by at least one and sometimes two care staff who must be ready to intervene. So there's very extensive supervision going on here, but it's done at 5, C just above E, appropriately experienced and skilled staff, as one would expect, but no staff with medical or nursing qualifications. Paragraph 6, we then see the wording of the relevant regulations, which we've already seen. The virus provisions in primary legislation. So regulation, section 73(1)(b) refers to the making of regulations to provide for adjusting benefit payable to or in respect of the person, where the person is or is treated under the regulations as undergoing medical or other treatment. And then the legislation defined medical treatment in a very similar way, with one minor change to the way that our regulations define it. So in the legislation, medical treatment was defined, and this is the definition that this court was considering in Slavin. at paragraph 6, medical treatment is exactly the same, except in one wonders where the typo crept in, including any course of diet, says the primary legislation, including any course or diet, says our legislation. But otherwise, the two definitions are the same. So in this case, the court is considering materially the same definition of medical treatment as is in our regulations. Now, what we would say, in fact, is if anything, the wording in Regulation 153 is more narrow because of the limiting words in Regulation 1532. So what the court does is look at various authorities at paragraphs 13 to 21 in relation to the meaning of that phrase. We don't need to go through those. It then makes some further reference to the facts, see paragraph 23 and 24, and again you can see the extent in paragraph 23 of the supervision that is going on. And we can also see that the staff are actually administering medication, bottom of paragraph 24, but that was done by care staff rather than registered nurses. So what the court is faced with here is a situation of very significant needs being met by skilled staff. Then at paragraph 38, the court says what the issues are in the appeal. 38, page 152 of the authority bundler H. Taking the submissions in the order in which they were presented, the issues in the appeal are whether the care provided to the claimant by staff at the lodge amounts to medical or other treatment within the meaning of regulations 8 and 12A. So the court is looking at the definition of medical treatment, materially the same as ours apart from of, not or, and then a reference to other treatment. We say 1532 is more narrow because it's medical, physiotherapy or related or similar. So if anything, the phrase here is broader. It's right that it was medical or other treatment in a hospital, but we say when one looks at the decision, that's not the basis on which the decision was made on the meaning of medical or other treatment. So paragraph 53 then summarises the authorities and the meaning of medical or other treatment in the context of these regulations, and it says this: the main authorities, fourth line, established that the expression medical or other treatment is to be read as including nursing as well as medical and dental treatment. The inclusion of nursing results from reading together the statutory definitions of hospital and illness. So that's how you get nursing brought within it, because you've got the word hospital, as appears most clearly from the passage quoted at paragraph 15. So looking at those cases, the court says that the claimant can only be said to be undergoing medical or other treatment if the care amounts to nursing. So it's a high bar. And then it says that there is no nursing going on here, C55 at C. It's the second line, sorry, it's staff are trained to handle challenging behaviour and to support in other ways, but they do not have professional qualifications or training as nurses, nor do they work under the supervision of qualified nurses. It's true that they look after residents who, in the case of the claimant, suffer from a disability of the mind, but it doesn't follow that the care they provide is nursing care. And in my view, it can be fairly described as domestic care rather than nursing care. And then goes on to say management of challenging behaviour is no doubt demanding, but it doesn't constitute nursing. Support of residents in the administration of their medication is not sufficient to give the care a nursing rather than domestic or personal character. And then this at 56, even if medical or other treatment has a wider scope than medical, dental and nursing treatment, I still don't think that the care provided at the lodge amounts to treatment. So there, the wider phrase medical or other treatment, it's still not within it, this supervision and so on that is going on. we say translated to our case where what's necessary is medical treatment, physiotherapy or related or similar treatment going on abroad, that the circumstances of this case couldn't possibly meet the meaning of treatment for those purposes. In paragraph 58, we see that Lord Justice Richards says this: if the claimant isn't going medical or other treatment by reason of his residence at the lodge, no useful purpose is served by separate consideration of whether the lodge is a hospital or similar institution. I don't think that it is, but that's largely because it's not providing medical or other treatment to its residents. And for much the same reason, I don't think that its residents can sensibly be described as inpatients. I might, however, have taken a different view if I concluded that it was providing medical or other treatment. So what leads the court's decision is not the words hospital, it's the meaning of the words medical treatment. I don't need to take the court to them, but we've sidelined other passages because there are two concurring judgments. Perhaps it's just worth showing the court paragraph 76, which draws a distinction between treatment and mere care, and you've seen that in the regulations. And then at paragraph 78, the Justice appealed that the nursing must be of a professional character, that is administered by or under the direction or supervision of a qualified doctor. And so the claimant, despite all the supervision and so on that was going on, was not undergoing medical or other treatment by reason of his residence at the lodge. And it's not necessary to give separate consideration to whether it's a hospital or similar institution. So we say that that case decides that a high bar applies before something can be medical or other treatment. And given that our provision is more narrow, in a sense, it brings in physiotherapy, but other than that, it's not medical or other treatment, it's medical treatment, physiotherapy, or related or similar treatment. So that's Slavin, and then I was just briefly going to show the court the cases, two older cases, and then the Cruz case, just to show how the Social Security Commissioners, as they then were, the predecessor to the Upper Tribunal, dealt with these matters, albeit different legislation and a long time ago. So the first case, and this is mentioned in the Cruz case, is at tab 4, mercifully brief, page 24, paragraph 2. The claimant was incapable of work by reason of anxiety neurosis. Medical terminologies have been moved on since then. Was advised by a doctor to go to Austria to a quiet place to enjoy mountain air, a complete change of atmosphere and rest. He supplied her with such medicine as she was likely to need. And the answer, very briefly, is I don't think the enjoyment of mountain air or a change of atmosphere or rest can be described as being treated. Being treated must, I think, import some activity by someone other than the claimant. The mere fact she was acting under the advice of her doctor doesn't seem to me to satisfy that requirement. And we say, A41 here, repeating what I said about carrying out or providing medical treatment in the other country. There's then another case at tab 5, which we say wouldn't now succeed under the legislation as it is now. But what happens in this case is that paragraph 2, tab 5, page 25, the claimant is advised that he's got to have 4 weeks complete rest in a warm climate. But what he does, he doesn't just go to the warm climate, that wouldn't have been enough. He goes off to a spa in France and later to one in Spain. And at the spa in Spain, he consults a doctor. But he's not undergoing the baths and massage under supervision by a doctor. At paragraph 4, we see the old statutory language. The question being, is somebody absent from Great Britain for the specific purpose of being treated for incapacity which commenced before he left Great Britain? so wording's been tightened up, as the Upper Tribunal rightly said. And then paragraph 6, the reason that this claimant succeeds is because he was being given medicinal baths under supervision, albeit not medical supervision, and therefore there is activity by someone other than the claimant. Now we say that wouldn't succeed now because going and having medicinal baths wouldn't be having wouldn't be having treatment carried out by or under the supervision of a qualified person. But those are cases mentioned in the next case, which comes, I think, to this court. So that's at tab 6. It's RS in brackets 269. The facts at paragraph 2. The claimant is a consultant physician. He suffers a severe coronary thrombosis, and then he's incapable of work. Throughout the relevant period, the claimant was absent from Great Britain on a cruise, and then we see why it was suggested that the claimant go on the cruise. See paragraph 4. So he stays in bed in Bournemouth for a month at subparagraph 1, but unfortunately his doctor takes the view he's not enjoying the complete rest from freedom and freedom from worry because he had a telephone by his bedside which constantly rang, and he's visited by his secretary and other persons on professional matters. So not the scourge of email, but even worse. So basically his doctor says you better go on a cruise, and they pick a cruise with a medical officer on board, goes with his wife, who's herself a qualified doctor, albeit not in practice, and while on board she exerted her influence to ensure that the claimant refrained from too much exertion. So she's helping him relax and so on. She's not doing anything else. And then there is actual evidence from a cardiologist. And he says, well, yes, the essential requirement is rest. And you've got to be free from worry, which obviously wouldn't happen if one's secretary keeps turning up. Dr. Baker considered that a cruise in sunny waters provided the ideal conditions and environment to ensure the rest necessary to effect a complete cure. The Commissioner decides the case at paragraphs 6, 8 and 10. What the Commissioner says is, at paragraph 6, we've sidelined it. Yes, rest is the recognised and necessary medical treatment, but what's being done here is rewriting the regulation as the second paragraph here, so as to substitute for the words being treated some such words as recovering or convalescing. I cannot accept that he is absent for the purpose of being treated. I accept the cruise was beneficial and assisted recovery, but I'm unable to see that it involved the receipt or administration of any kind of treatment. And then at paragraph 8, but there's 2 paragraph 8s, it's the second paragraph, paragraph 8 over the page. It goes to some older cases, and the Commissioner says, I'm not going to attempt an exhaustive definition, but a person can only be absent for the purpose of being treated if he's absent in order to enlist while absent some kind of medical or surgical skill or service to be administered by some person qualified to supply it.
I'm so sorry, I was making a note of the last, I missed where you were reading from there.
I'm sorry, it's the second paragraph 8. So there's paragraph 8 and then an unnumbered paragraph below
Yes.
it. I'm sorry, it isn't sidelined.
It is to be observed that.
Exactly.
Mm-hmm.
So he's saying he's not trying to give an exhaustive definition, but it needs to be getting some kind of medical or surgical skill or service to be administered. Now we say the wording now does make that clear on our approach, because it says the treatment's got to be abroad and somebody's got to be carrying it out. And then there's a reference to the wife, and that's rejected on the statutory language. And then we get the Lord Chief Justice on page 33, and it seems that the equivalent of the Secretary of State isn't called on. And the court goes through the evidence, and then on page 36, the court, in the first paragraph on page 36 of the authorities 72 of the report says why there is an argument that the Upper Tribunal was wrong, and then the court's answer is sidelined in, I don't propose to attempt any definition, it's very advisable in a case of this sort, but I rest my decision on the narrow ground that where a person goes abroad merely for the purposes of rest and freedom from worry, in order to allow nature to continue the care and recovery, that he's not going for the purpose of being treated. So it's...
I think you made a rather significant error when you read that
Did
out.
I-
It's to cure and
What
recover.
did I say?
Care.
Care. Yeah, sorry, to allow nature to continue the cure and recovery.
Mm.
Yes. But if it was nature continuing the care, it would be even less likely to succeed because it's not treatment at all if it's care. But yes, sorry, if we continue the cure and recovery.
Also, he said very inadvisable. I think you said advisable.
He definitely
Sorry.
said very inadvisable.
A
Yes.
very pedantic
No,
intervention
I
by
think-
me.
I don't think those are pedantic points, they're actually quite important. But yes, he does say it's inadvisable to attempt a definition, and we say that's right. And what one has to do is look at the language and whether it's met on a particular set of facts, albeit that there are certain things that on any view couldn't qualify, and that's our position in this case. And then just at the top, a pretty brief point in relation to the wife. He didn't go abroad for the purpose of getting her assistance. She was his wife and accompanied him as his wife.
Where's that?
That's at the top of 37. And we say, although different statutory language, that a similar point applies here, but a fortiori, given the statutory language. What in effect the tribunal finds is that the appellant's husband is going along to support her with her position, but he clearly isn't carrying out any kind of treatment. The final case, just to note, although it's a discrete point, is at tab 9. There's a separate point about what happens, and it's not this case, if somebody goes abroad and then while they're there decides to get medical treatment. And this case, at paragraph 29 and 30, essentially decides that the purpose has to be formed before leaving. So for the court's note, it's tab 9 of the authority bundle, paragraphs 29 and 30 on page 75, and that in our permission to appeal skeleton we mentioned that there were some pending cases in the Upper Tribunal on that issue. One of those has now been decided along similar lines, albeit in relation to different language in the universal credit legislation. Just for the court's note, I don't need to go there, that's at tab 17 of the authorities bundle at paragraphs 129 to 154. But that's a different point. That's about what if something happens when you go abroad.
Tab 17, page.
210. And there's. Don't start reading the decision and thinking that the early paragraphs are the court's answer, because they're a recitation of the submission. So the answer on that point begins at paragraph 129. Now, but that's a different issue from the issue in this case.
And I'm so sorry, Ms. Mandel. You took us to page 75.
Yes.
9. I think you took us. But there are no sidelines. So could you just remind me which paragraph?
Yes, paragraph 29 and 30.
Thank you.
So that's just really because we've mentioned the point in our skeleton that you can't form your purpose when you're abroad.
Mm-hmm.
That's just the authority for that.
Why is that particularly relevant here?
It's not. It's really for completeness. That point. Yes, yes, we've mentioned it, and it's just showing in effect how the provision works, but it's not particularly significant, perhaps not significant at all. So that was the second part of my submissions, and that then takes me to the third and final part, which is deal with the Upper Tribunal's decision and our grounds of appeal. So at that point, can I just invite the court to turn back to the core bundle? Our grounds of appeal are at tab 7, beginning on page 72. So, 3 grounds. Ground 1 is an error in construction in principle, and what we've tried to do is break that down, but we've made the point in the grounds that that's quite, I haven't said it quite like this, but it's quite a difficult exercise because you've got to construe it as a whole, but effectively those grounds are us saying the tribunal's erred in its construction in principle. The second takes 2 points which follow on. The first is that it follows from our point that what you have to do is look at the entirety of the absence, that effectively what the first tier decided was that the reason for the extended absence was for the purposes of sunlight, so that on our construction is incapable of meeting the test. And the second point, and we accept that it wasn't put in this way below, and I'll come on to that when I deal with ground 2 after the Upper Tribunal decision, is that there is no finding that the I've been calling her the appellant, apologies, she was the appellant below, I'm the appellant, but in fact it's easier to call her the appellant because she's referred to as such in the Upper Tribunal. No finding that the appellant's husband supervised her treatment in Spain. That's the second limb of ground 2. And then ground 3 is a perversity point. I accept that faces a high hurdle. I'll deal with that at the end. So those are our grounds. With that then, could I make them good by turning to the Upper Tribunal's decision? And that is at tab 8, beginning at page 78. And the Upper Tribunal, and we absolutely make no criticism of it for this, also breaks things down into different headings. It's a difficult thing to do, but it has to be done to some extent. So what I'll do is follow the breakdown that the Upper Tribunal's adopted. So I'm going to start first of all with what the Upper Tribunal says about, it calls this A, begins at paragraph 23 on page 86. So this is the exception in Regulation 153 doesn't apply unless the claimant is absent solely in connection with arrangements, etc., etc. So this is really the solely point. So paragraph 26, the Upper Tribunal, 3 lines from the bottom, says the reason or purpose is to be judged objectively. We agree. Paragraph 27, the Upper Tribunal makes the point that this legislation is a tightening up of the wording in the predecessor legislation. We agree. Paragraph 28, the Tribunal makes the point that the fact that somebody does things other than being treated doesn't mean they're not absent solely in connection with. For example, the fact that someone goes abroad for the purpose of treatment, has breaks in between to go swimming or eat unreasonably or engage in sightseeing, doesn't necessarily change the purpose of the absence, although both parties accept that it might if the Tribunal concludes that the activities engaged in between treatments are actually part of the purpose. We agree with that. And we agree with the Upper Tribunal when it says that solely doesn't allow for any dominant purpose type test. As soon as there's more than one purpose to the absence, Regulation 153 ceases to be satisfied. So we accept all of that. We say where the Tribunal goes wrong is in paragraphs 34 onwards. So paragraph 34, the Tribunal recalls the Secretary of State submission that if the Tribunal had taken the correct approach to solely, it would have to have concluded that NJ had more than one reason for staying in Almeria. At least the Secretary of State says it was clearly a holiday as well as treatment. However, the tribunal has dealt expressly with that, and the reasons it gives were adequate and not perverse. But the difficulty with that is it's not a perversity point. The point is about the construction of Regulation 153 and the need for there to be a sole purpose throughout the relevant period. What really the first tier and the upper tribunal have done is try to get around that by saying, well, no, you've just got to look at the reason for extended absence. Why have they done that? Obviously, because it's quite clear that if you look at the whole period, it's not just treatment, it's also a holiday. So paragraph 35, the upper tribunal does the same as the first tribunal, and it upholds the tribunal looking at the reasons for going to Almeria for extended periods of time, and says in paragraph 35 it's right to do so because as both parties accepted, the exception only becomes relevant after the Regulation 152 exception has been exhausted. Well, if we did accept that, it was wrong because, for the reasons that I've submitted, Regulation 152 and Regulation 153 are discrete, and the wording is the wording.
Can I just raise with you a query that links to that, which is the payment of the ESA?
Yes.
Because NJ received, as I understand it, NJ received effectively the 4 weeks of ESA payment for the periods when she was absent in Spain, but not for the weeks 22 to 20 or 23 to 26, or 1 to 26.
Yes.
And that might have led the judges in the FTT and the UT into this error because it appears as if your client was treating the first 4 weeks as a period when she was entitled, but not the extended period beyond that.
What we would say the Secretary of State was doing was simply applying Regulation 152.
To strictly.
Yes, so
Yeah.
applying whatever was said,
Yeah.
it's Regulation 152. So she's a Regulation 152 case.
For the first 4 weeks.
Yeah, so she gets 4 weeks because she's a Regulation 152 case, that's separate, and then Regulation 153, she doesn't fall within it. So instead she gets what she gets under Regulation 152.
But the clock has started for 153 at the same place.
Yes, and that's why it's a different provision.
Yeah.
Yes. So paragraph 35, we say that that's wrong for the reasons I've already given, because Regulation 153 requires you to look at the entirety of the period, and if part of the purpose is a holiday, then there's a dual purpose and you're disqualified, even if for weeks 5 and 26 you would have been there doing treatment. And then at paragraph 36, there's a quote from the paragraph 31 of the first tier's decision, which we've already looked at. And we say that makes it clear, and I appreciate the point that my Lady Justice Whipple put about simply spending, but when that's looked at with the relevant bit, paragraph 18 and the end of that paragraph, we say it's quite clear that the upper tribunal is looking at the reasons for extended absence because it doesn't think that the whole period is for that purpose. And then at paragraph 37, it's clear that the upper tribunal recognises that there are some issues here because it says many tribunals wouldn't have reached the same conclusion but the decision wasn't perverse. Again, we say that's not a perversity issue, it's about applying the wrong test. And it can be seen again from that there's 3, I think, references in paragraph 37 to this extended period of time test. So line 6, line 8 and line 11, there or thereabouts. So again, we say that that's the wrong test. It's not perversity, it's just the wrong test.
If the FTT had not referred to extended periods of time and had just said that the FTT judge was wholly satisfied, this wasn't a case of a couple simply spending time holidaying, they went to their home in Almeria because the climate provided respite, full stop, then you would be saying that was a perversity.
That's our ground 3.
Yeah.
Yes.
But there wouldn't be anything. Yeah, okay. Okay, so
Yes, we'd say, I mean, it wouldn't be the only reason it would fail, because it's not just sole, it's treatment and carrying out.
yeah,
treatment
all
and
that stuff.
Exactly,
But,
but yes.
no, I'm just a bit stuck on that. You know, I think there are just, for my part, I think there are different ways of reading that sentence. It may not matter.
Yes, certainly we say that however the sentence is read, the Upper Tribunal applies the wrong test.
They are very focused on the reasons for the extended period as opposed to a normal less than 4 weeks period.
Exactly, and certainly we would say that the Upper Tribunal, as we understand it, has read the first tier as doing the same, because it's effectively upholding its reasoning and saying, well, it made this factual finding about extended periods, but why was anybody worried about that? Because it's quite clear that it was also a holiday home. Sorry, can I just turn my back a moment? Yes, I think essentially what we're saying is that the tribunal, both tribunals are effectively accepting more than one purpose if you look at the whole period, but actually they square the circle, they deal with the problem by saying, well, don't worry about that, look at the reasons for extended
They're really doing a
absence.
sort of predominant purpose thing, aren't they?
Yes.
It's really, if you think about it, they're saying, well, yes, they have a holiday home there. Brackets, of course, you want to go to your holiday home, but that wasn't the main reason why they went for these particular periods that we're talking about. But you say that's a bad reason.
Yes, and the Upper Tribunal itself accepts that. At the bottom of paragraph 28, the Tribunal says, I would agree that solely doesn't allow for a genuine purpose test, and we say that's right.
So it's internally inconsistent.
Yes, exactly. And that's why it then finds a way to uphold the first tier by saying, well, look at the reasons for extended absence, but there's no basis in the statute for doing that, in the legislation.
I haven't really thought this through, but it may be that this is where the case that holds that you have to have the purpose before you go might be relevant. It almost sounds as though they're saying, well, don't worry about the first period or why you went, but
Yes.
the second period.
Yes, yes, that's right, because the purpose is effectively one purpose is formed before you go, and connected and linked to the solely requirement, that purpose has to be your only purpose. And so if for the first 4 weeks you're doing something else, it's more akin, and perhaps this does make those cases I mentioned relevant, it becomes more akin to those cases, not the same, because you leave with two purposes, but it becomes more akin to cases where you went on holiday and then you became sick when you got there. But in a sense, there isn't a logical or coherent reason, we would say, for distinguishing between those two classes of case, and indeed the legislation doesn't, because it says look at the whole period. It's about somebody expressly travelling only for the purpose of receiving treatment. The difficulty, of course, with this case, we say for the respondent, not for us, is that really the difficulties stack up, because there's the difficulty that it was actually just going to take advantage of the climate, which means that all the difficulties come together, the solely, the treatment, the appropriately qualified.
Well, the fact that it was their second home is you'd be running many of the same arguments if they'd been to stay in a hotel in the south of Spain,
Yes.
because that was conducive to health and sunlight was good.
Yes, although we would say on the fact, if what you do is go and stay in a hotel, you're more likely to do that if you are just going for treatment, because it's on a one-off basis.
If you were I was trying to just change the holiday home bit of the fact pattern here. So you had the same couple, same problems, same decisions, research, everything else, deciding that sunlight is a good way of helping OCD, and I suspect there's some truth in that.
Yes.
But they don't have a second home. They just go and stay in a hotel to get the sunlight. I mean, the arguments would all be the same as the construction point.
That they'd still lose. The only difference would be that they might have a slightly easier time on solely because they're not always going there in any event.
Yeah.
But that's
they wouldn't have been going there since 1990, whatever it
yes,
was.
exactly. 2012. He buys it in 1987.
That's right.
Yes. So yes. So that 1 moment. So that is solely. So the next limb is B, and that's arrangements made for the treatment of the claimant. So paragraph 39, we see the Secretary of State submits that sitting in sunlight is not treatment. We maintain that point, and Mr. Edwards says something that one does to oneself is capable of being treatment. is not capable of being treated under Regulation 153, well, we can maintain that submission. And then paragraph 40, Mr Edwards further submitted that merely making travel arrangements couldn't be arrangements for treatment. He submitted that it was apparent that arrangements had to be the kind of arrangements that a medical professional might make, not just travel arrangements or sitting in the sun. We maintain that submission. Paragraph 43, we then say that the upper tribunal, paragraph 43 onwards, we say that the upper tribunal errs. So could I just invite the court to read paragraphs 43 and 44 of the decision? So we make 3 points broadly about paragraphs 43 and 44. First is where the tribunal says that the definition of medical treatment in Regulation 2 is broad, and then says from which it's clear as a result of the reference to diet or other regimen that medical treatment can be something that one does to oneself without any direct third-party involvement. However, Regulation 153 isn't even limited to medical treatment, it just refers to treatment. We say, in fact, it's not broad, it's narrow. First of all, medical treatment isn't broad, see Slavin. That's the first point. The second point we say is that the words in the definition of medical treatment of diet or other regimen don't involve giving treatment to yourself, because in effect, regimen is indicating that a specific regimen is prescribed, to use that word in a broad sense, as opposed to in terms of medication. So that doesn't cover being outside in sunlight. And the third point, just to repeat, is that treatment has to be read in the light of Regulations 153, I think it was 1D and 2, and that means it's got to be medical treatment, physiotherapy or similar, and that the treatment is carried out or provided out of country. So if somebody says, doctor says, oh, you're going to France, when you're in France, I want you to eat this particular diet, we would say that's not covered by the legislation, because it's not medical treatment, physiotherapy or similar being conducted out of country. That's not this case. This case fails for other reasons. But we say that the Upper Tribunal is simply wrong here in saying that it's broad. It's not.
I haven't quite got the diet point. If you go abroad for medical treatment and while you're there,
What if you're going abroad for medical treatment and as part of that a diet, yes. But a doctor saying go to France because
Have a
baguettes
nice
are good
holiday,
for you,
yeah.
yes, it would be different, it wouldn't be covered. So for example, if somebody, in fact they were going abroad for some sort of gastric surgery and as part of that they were told you can only eat very plain food, yes, that would be part of the treatment, but it's not, that doesn't help. None of this helps establish that there is a broad definition of treatment such that doing something to yourself without any direct third party involvement is good enough. It can't be, because the regulation tells us that when you are abroad somebody has to be carrying out treatment on you or supervising someone else who's doing it.
Can I just ask whether you are reading, including any course or diet or other regimen, as referable only to rehabilitative treatment?
I don't think we necessarily need to read it in that way,
No.
but the difficulty is, I'm sorry, I was looking for a tissue. The difficulty is that medical treatment is narrow,
Yes.
so medical treatment, surgical treatment are, I'm so grateful to my learned friend.
well done, very impressive.
No, it wasn't impressive.
Copious pockets with everything.
There and ready. Nice tissue. So medical treatment we know from Slavin
Yeah.
is limited. Surgical treatment is obviously quite clear. Rehabilitative treatment, if one's looking at the definition of medical treatment, we would say that would ordinarily, one doesn't want to rule anything out, but ordinarily that would follow on from medical or surgical treatment. Certainly in the context of our provision, which is Regulation 153, which requires either medical treatment, physiotherapy, or something similar, one can see that physiotherapy would be rehabilitative, but for the reason I gave, probably just going abroad for physiotherapy would fail for other reasons. But to say to somebody just go to France and eat this particular diet is not that person having
No.
treatment carried out in France on them.
No.
So in terms of does regimen link only to rehabilitative, I wouldn't want to speak for where that crops up in other provisions, but for our purposes, rehabilitative has to be read subject to the more narrow words of Regulation 1532.
I mean, speaking of myself, if one read that definition section and took out the words medical or rehabilitative and simply said medical treatment means surgical brackets, including any course or diet or other regimen, it doesn't make any sense.
Yes.
So
yes, because surgical doesn't.
surgical would not seem to include, for example, diet or other regimen. So that's why I currently prefer the idea that that refers only to rehabilitation.
Yes, and that may well be right. But yes, but in our case, I mean, obviously that doesn't help. That doesn't help
No.
the appellant. It helps me. But in our case, it's more narrow still for the reason I've given.
Yeah, I understand. Thank you.
So in other words, the language of 153 paragraph 2 suggests that the broad definition in regulation 2 is narrower, narrowed down specifically by 1532.
Precisely so, my lady, and that's why one has to read everything in Regulation 153, read it as a coherent whole and ask what was intended, and that must be what was intended. Because it's the definition of appropriately qualified, and that's a core condition in legislation. I think that our core point really on 43 and 44 is saying that you can treat yourself simply doesn't give any proper effect to the requirement for treatment to be carried out or provided out of country. Because that isn't doing something to yourself. Absolutely not. And then at paragraph 47, the Upper Tribunal says rightly that mere rest or convalescence or a change of air could amount to treatment under the current regulations. Well, we've already seen that convalescence is different because the regulations use that term elsewhere. But in relation to paragraph 47, the Upper Tribunal goes on to say in due course that the sun is an agent, but if the sun is an agent, then air is an agent as well. So really that there's inconsistency there. What the judge is doing here is indicating an active agency test, and we say that that's simply not the test, and I'll come on to that shortly. At paragraph 48, the judge makes the point at the bottom, and rightly we say, that a tribunal has to be aware that mere provision of care is not treatment. Yes, we agree. Then the tribunal says, however, the Secretary of State has not suggested that the tribunal in this case erred in failing to make such a distinction. Well, that's our ground too. I am making that point now.
I'm so sorry. I'm
sorry.
You are.
Sorry, my
Did you just go back to the last point?
Yes, so paragraph 48.
48, thank you.
The judge says, one might therefore also conclude that a tribunal dealing with Regulation 153 has to be aware that mere provision of care is not treatment. We say that that's right. You see Slavin. Then the tribunal says, however, the Secretary of State hasn't suggested that the tribunal in this case erred in failing to make such a distinction. This is our ground too. Now, whether or not the Secretary of State made the point, if the test is that care isn't good enough, and if on the evidence that's what the appellant's husband was doing, then regardless of whether or not the Secretary of State takes the point, there is simply no entitlement to benefit. Now again, there are so many difficulties in this case with meeting the conditions. It's not, the case fails for all manner of reasons, but we do make the point that the tribunal's direction here is correct. And as I showed the court earlier, there is nothing in the first tier's decision to say that Dr. J was providing treatment of any kind. And clearly, the Secretary of State's point is, well, no, of course he wasn't, because sunlight isn't treatment. So it's not really a surprise that there's nothing in the decision to say he was providing treatment, because he couldn't have done. First tier's decision is really what he's helping with her care. But that rather reinforces the point under our Brown 1 that sunlight isn't treatment. Paragraph 49, the judge accepts that the treatment needs to be similar to or related to medical or physiotherapy treatment. Well, that's my submission. The difficulty is that the tribunal didn't apply that test.
It's also slightly inconsistent with what the tribunal said earlier about the relevance of the definition of regulation 2.
Exactly, because it's more this is more narrow, and that's exactly my point.
Yeah.
And the tribunal rightly says you have to limit it like that, because otherwise the person isn't going to be appropriately qualified.
Yeah.
So we agree with the tribunal there, and then we get application of an agency test. So paragraph 50 says, I've no difficulty in accepting as a matter of principle that the tribunal didn't err in law in finding that exposure to sunlight is treatment. The element of agency in this case is provided by the sun. I see no reason, it's common knowledge that we create vitamin D from sunlight, and I see no reason why exposure to sunlight can't in principle constitute a treatment. Well, that may be so, but that isn't the statutory test. What it's doing is saying, well, as long as there's some sort of active agency abroad, that's fine. But the difficulty with that, one, is that it needs to be a very particular form of treatment, which is what the tribunal's just said in the paragraph above. Second, on the authority of Slavin, sun couldn't possibly be medical treatment, nor is sun physiotherapy, nor is it anything similar. Third, this completely negates the requirement in the legislation that in the other country there has to be somebody who is carrying out treatment or supervising somebody else who's carrying out treatment. So this agency test simply doesn't work, we submit. The other point here is that what actually is the treatment? What the first tier is saying is, well, Dr. J, they both noticed the sun was helpful, they both researched it. Is that the treatment? But it can't be, because that happened here. And in any event, they both did it. Anybody can do that. What happens, what Dr. J does in Spain is helping her with her condition. So if one takes a step back and says, well, what's the treatment that was being carried out in Spain? There isn't any. And then at paragraph 53, the Upper Tribunal says, well, it is treatment because that's got to be, it's similar to taking a pill. But again in our submission, that's the wrong approach. If somebody goes abroad for 26 weeks for a holiday and is taking a pill when they're there, that doesn't mean they're having treatment. But in any event, the requirement is not to be taking some kind of medication when you're away, whether it's sun, if sun could be medication or anything. It's for somebody to be carrying out treatment on you. And then finally, paragraph 54, although nothing turns on it for all the other reasons, we say that arrangements include travel, living in the property and exposing oneself to the sun is arrangements for treatment. We say that that's wrong because it's clear if you read 153 as a composite whole that the arrangements are made for treatment, and then what you have is the giving of treatment, the carrying out of treatment by an appropriately qualified person. So we say that all of those bits of the Upper Tribunal's decision are wrong.
The premise of 153 is that you have travel abroad, so how could arrangements for travel be?
Yes, I mean, it's just not, that's necessarily, if you're going abroad, you have to make some arrangements, but making arrangements for travel isn't good enough to satisfy the provision. And clearly when one reads it as a whole, it's clearly envisaging a situation where somebody goes abroad for actual treatment, treatment being something that somebody does to them, broad terms. And then finally, appropriately qualified. We see the Secretary of State submission recorded at paragraph 56. Mr. Edwards says he's not appropriately qualified. And then 5 lines down, Mr. Edwards admits that evidence is contested as to whether it's a treatment for OCD, but in any event, the more innovative or experimental the treatment, the more qualified a person must be more to be appropriately qualified to supervise. Now, of course, we say one doesn't even get to this point for all the other reasons, but nonetheless, we maintain that the person, and this is to answer my Lord's question, Mr. Edwards submits that 6 lines from the bottom, the person must also be registered. So the fact that Dr. J is retired means that he's not appropriately qualified. But again, this illustrates the sort of patchwork of different things to try and bring this couple into the provision. It's clearly not what it was intended to cover. So paragraph 55, the answer the tribunal gives is to reject that submission. It says this: qualification, paragraph 58, doesn't on its natural meaning encompass registration. Further, I don't see how this could be a requirement, given that the treatment that the person has to be appropriately qualified to provide doesn't even have to be medical treatment. The forms of treatment can thus evidently cover treatment by professionals of types for whom there are no registration requirements. Well, 2 errors in that. One, it's a misdirection in terms of the broadness of the types of treatment covered. It doesn't take into account 153 sub 2. In any event, whether or not somebody is appropriately qualified will depend on the nature of treatment. It can't be right that if a person needs to be registered and they aren't, they're still appropriately qualified because a person given a different treatment wouldn't need to be registered. But in any event, we say this simply doesn't stand up to scrutiny for the first reason, which is the broadness of the treatment. And then
also, do not have to look at 153D3 to carry out, appropriately qualified to carry out that treatment.
exactly, my lord, yes. So it's specific, appropriate that
to the specific treatment that it is said the person is receiving.
precisely so, my lord. And then at paragraph 60, the tribunal says this: there are no restrictions on who can supervise a regimen of exposure to sunlight. Well, 3 points. First of all, there's no finding to support that because the tribunal didn't make a finding that he was supervising exposure to sunlight. And clearly he wouldn't have needed to have done. What he was doing was helping her, providing care for her condition. Second point, there wasn't anything which could properly be described as a regimen for all the reasons I've already given. In other words, we're simply outside the scope of treatment altogether. And third, we say that the fact that anyone really could suggest, having done some reading, to go and expose oneself to sunlight, and the fact that anyone could do that or go along and help somebody with it rather reinforces our point that it isn't treatment. And then the last paragraph, in paragraph 62, the tribunal says at the 3rd line, whether he was appropriately qualified or not was a question of fact for it to determine. We say no, the meaning of the legislation was a question of law, not a question of fact. it will be, of course, that having appropriately directed itself, the tribunal then needs to apply the legislation to the facts. But here, the tribunal has misdirected itself, so it is a question of law. The final point that we make then is in relation to paragraph 70 and 72, where the Upper Tribunal is at pains to say that this turns on its own facts. It's basically warning other claimants, really, don't think that you're going to be able to get anything from this decision. We say that that really does show that the tribunal has got to the wrong decision, because the construction of the Upper Tribunal is that somebody who happens to have a friend or family member who's a medic is able to take advantage of sunlight, provided that the person goes with them, and someone who's equally well able to look that up for themselves but doesn't have a medic doesn't qualify. And we say that is not a rational or coherent interpretation of this legislation. One has to recall that this is social security legislation, and it needs to be interpreted in a coherent and logical and consistent way. And so for it to be interpreted in a way in which we end up with, well, just because of that very strange combination of facts, the person could qualify, rather shows in our submission that it's wrong.
Isn't it slightly worse than that? Because the FTT said in subparagraph R on page 1 about claimant's husband, he remains on the register, but he's no longer licensed to practice medicine.
Yes.
So the Upper Tribunal hasn't fully reflected what the FTT found about the potential qualifications of the husband.
Yes, absolutely. And that it is this very, to say, well, it's just an unusual case on its facts, but nonetheless they can shoehorn themselves within the provision is simply not how the social security legislation is interpreted, particularly on facts like that with those particular features. But the reason that we have the tribunal, both tribunals in fact saying, look, this is just a one-off, is really because they're plainly uncomfortable with the result that they've come to, and rightly so, for all the reasons that I've been giving. So we address that point about logical and coherent approach in paragraphs 45 and 46 of our skeleton. The point was taken against us, saying, well, just because some people don't have the right evidence doesn't affect the interpretation. Well, no, that's not the point. The point is about interpreting the substantive conditions as a matter of law so that they don't have odd and strange results. But in any event, that is in a sense a subsidiary point, because we say the legislation is clear and both tribunals have gone wrong in interpreting it. So that means, I think, that I've addressed my grounds of appeal, but just to turn them up for completeness, and then I will sit down. They are at tab 7, page 72. Ground 1 I've addressed, it's that the tribunal errs in principle in relation to its construction of the legislation. So that, I think, I have dealt with. Ground 2 is that the statutory test isn't capable of being met on the findings. So the first is, it's linked to our point about purpose throughout the 26-week period. So ground lim A of ground 2 is dealt with in paragraph 38 of our skeleton. We've addressed that, I've addressed that, I think, already. And the second part I've also addressed in my submissions, that the first tier didn't actually find that he supervised treatment, and indeed it couldn't have done because there wasn't any treatment to be supervised. But if we're wrong, and there was somehow some possibility of carrying out treatment being some, he didn't do that here, because what he was doing was assisting the respondent with managing her symptoms of OCD. So that's the way we put it in the grounds. And then finally, although we say it doesn't arise, and this is the point that my Lady Justice Whipple raised, that if we're wrong about all of that, this is a case where they've been going to Spain for some time, and is quite clear in reality there was a dual purpose. The reason that that doesn't arise is because we say the tribunals actually accepted there was a dual purpose, and that's why they came up with their extended absence thing. So ground 3 on our case doesn't actually arise, but it's there for completeness.
Do you say that ground 3, I was just a bit interested in the way it was phrased. In submissions you've coined it as a perversity challenge, but it doesn't actually say perversity in ground 3. But it's, I mean, when you say the right inferences weren't drawn from the primary evidence, maybe that is in effect a perversity challenge.
Yes, I suppose I'm using perversity in a global sense for all the ways that somebody can attack the findings of a tribunal, but perhaps I'm being too narrow. In a sense, it is failing to deal properly with the evidence and therefore reaching a conclusion which wasn't reasonably open to it.
And that could mean that the sole purpose was for curative for treatment, when you'd say on the evidence as they had recounted it, there was plainly something else. There was a corollary purpose or a subsidiary purpose. There was something else going on as well.
Yes, and that's the case of Manu and Drummond, which we had in the bundle, but I probably
An old
don't.
friend.
Yes, an old friend, exactly, because poor barrister in that case was having to buy court dress, but she also needed to keep warm. So she would say, excuse me, I'm only buying these clothes because I have to wear them in court, but the court said, no, that's a dual purpose. And we would say a similar sort of approach applies here when you have a holiday home. That is a dual purpose. If we're wrong on everything else, the reasons plainly on the evidence for the couple going to Spain were that they owned a house and holiday there. Indeed, that the first tier makes that point, but it says it doesn't matter because we're just going to look at extended absence. So for that reason, our ground 3 doesn't arise. Can I turn my back for a moment? Just call up any questions for me, otherwise that's it.
No, thank you very much. Yes, thank you very much, Mr. Jackson.
Thank you, Melody. Could I just begin by saying, in our skeleton, we refer to the Secretary of State as her a number of times. I should say, of course, that the Secretary of State has changed since we did that, so I think it should say that the her should be him because of the change of sex, but I don't think anything else will turn on that. You should, I hope, have a paper copy of that skeleton on your bench, which I handed up this morning, because we had admitted to doing that, which Ms. Matt very helpfully reminded us yesterday, which is add the page numbers to that. So you should now, I hope I have a version with those page numbers on it where they are necessary for the core bundle and the authorities bundle. It's in all other ways the same as the document you already have. Can I then also, just as sort of headline points, set out a few points, and I think possibly one point where we definitely agree with the Secretary of State, and that is absolutely in relation to the word solely as it is used within the regulations. There is no disagreement at all that a mixed or dual or more than dual purpose is in any way of assistance to this claimant or indeed any other claimant. The finding must be that the sole purpose of the absence is that in the regulations and not anything else. We do, however, say in slight departure, I think for the way it's put, although I may be being unfair, that is a question of fact. We don't agree that there has been any elision between regulations 152 and 153, which I'll expand on briefly now, but I will cover slightly more detail later if I may. And the reason I say that is this: could I invite the court first of all, please, to the original decision, which is in the core bundle at page 160. And one of the points I'm about to make comes from the heading you see there of short absence. And in the way that might be then contrasted with the extended absence, as it appears to have become quite a central feature of the Secretary of State's case.
I haven't got that. I'm sorry, I'm being dim. I can't see it. I'm on page 160 of the core bundle.
The version I have, my lady, has decisions, claims, revisions, supersessions, etc. at the top.
I'm sorry, I'm struggling to hear you as well.
I'm sorry, I have a slight cold. I'll try and speak up. The document at page 160 I have begins decisions, claims, revisions, supersessions, etc. at the top.
It's a page from the mandatory reconsideration notice.
I think it's 150. Isn't it?
Forgive me, I may have.
I think it's just if it's the page immediately
I
after
see.
tab 16.
Yes, forgive me. The electronic numbering has.
150, and the word short absence is in the middle of the page.
Forgive me, my lord. You're entirely correct. Printed numbering at the bottom goes through some other text, so it appears that way. Forgive me. I'll expand on this in a little more detail in due course. My essential submission on this is as follows. The way in which the Secretary of State has made submissions on extended versus short absence, as in some way aligning two separate tests, first of all, does not reflect that in this case, in fact, short absence was initially part of the consideration as appears in the decision notice. So it is entirely possible, and I will say the correct reading of the judgment is that when using the phrase extended absence, all the first-tier tribunal is distinguishing between that part of the decision which is in fact relevant, the short absence, and the extended absence which was for a longer period because that was part of the original decision. However, it also, in my submission, does not reflect the reality of the way in which these cases take place before the first-tier tribunal. The first-tier tribunal, regrettably, does not often receive submissions of the calibre that my learned friend has given to this court on precisely how the Secretary of State puts his or her case. You can see that to some extent if I can take the court to the supplementary bundle. And I won't go through the entirety of the documentation there, but first of all to page 2. This is the document which the Secretary of State placed before the first-tier tribunal, setting out his case to that tribunal. And the court will see in due course pages 3 through to 9, which I'll invite the court to read either now if the court wishes or later, it would be helpful. But the way in which that case is put to the first-tier tribunal does not in any way approach the sophistication of the way it's now being put, both on the first appeal to the Upper Tribunal and this appeal to this court. It does not suggest that there is some character or term of art in the way the tribunal must consider a distinction between 152 and 153, or that there is some special character of the way in which the then appellant put her case to the first-tier tribunal, which was, I have a single reason for leaving. That reason was making arrangements in connection with treatment, and that is why I left. Now, I'll come on to say in due course, that is what I say the tribunal finds. This distinction between extended and short can very easily be seen by this is what we are dealing with. There is a decision notice which deals with short absence. The corollary to that is that the other part of the decision is dealing with extended absence. That's all that is being talked about, and there is no suggestion in the wording of either the first tier or the Upper Tribunal's decision, I say, that suggests that this elision has taken place as is being submitted. I'll go through that, as I say, in a bit more detail in due course. But the other point I want to make, if I may, as a headline, is the submissions that were made to you, both orally and in writing, in a number of ways elide what the actual statutory words are on a number of occasions. So my learned friend said a number of times carrying out treatment, or using the phrase medical or other treatment, none of which appear in any of the regulations, which I will take you to shortly. It doesn't say medical or other treatment anywhere in Regulation 2 of the ESA regs or in Regulation 153, nor is the phrase carry out, as was suggested, because the submission was made a number of times, carry out or supervise, and that submission was made to distinguish between supervision of another person who was not a benefit claimant. That, I say, is not a permissible reading of the regulations, and the reason I say this now at the start is because the reason that came up as many times as I think it did is because the Secretary of State's position materially aligns the actual test, which you will find first of all in Regulation 2, and then the way we say it is widened by Regulation 153 and not in any way narrowed, as the Secretary of State says. So those are two headline points I said. Can I also very briefly set out the order of the submissions, which myself and then my learned friend are going to give in a moment? So first of all, I will very briefly deal with what we say is the function of this court and the Upper Tribunal. And I say that at this stage not to tell the court what it should know, because of course I'm sure the court does know. It's more in terms of what we will go on to say is that our focus, I hope for understandable reasons, is not on the Upper Tribunal's decision, meaning no disrespect, but in the conventional sense, this court is seeking for whether or not the First-tier Tribunal was entitled to come to the conclusions it did. Of course, one has to consider whether there's an error of law, but ultimately the question is, was the First-tier Tribunal right or entitled to come to its conclusions? I will briefly deal with the approach of courts to statutory interpretation and why that matters in this case. Then my learned friend will deal with the legislative history of some of what I'll describe as the incapacity benefits, because they're not all the same as employment and support allowance. Whereafter I will pick up on what we say, first of all, is the purpose of Regulation 153. Then what is meant by paragraphs C, subparagraphs, forgive me, C and D. And then the final point, which I'll come to, is whether or not the First-tier Tribunal was entitled to come to the conclusion that it did, and how this appeal ought to be disposed of. So if I may, I'll turn to the first of those points, which was the function of the Upper Tribunal and this court. It is, I think, not a point of dispute at all that the search in both tribunal and this court is for an error of law by the First-tier Tribunal. It must therefore be demonstrated to this court by the Secretary of State that there was an error of, as I say, law, not simply of fact. And I mention that because the way that grounds 2 and 3 are put, I say, are essentially re-arguments as to the facts which were found by the First-tier Tribunal. And I say it's respectfully not open to this court, in the circumstances of this case, to depart from them in the way the Secretary of State invites this court to do so. The nature, I say, of that error we say the Secretary of State is making on this appeal can be seen from the way the case has been put, not only orally, but also in the skeleton argument. So if I can invite the court to put the supplementary bundle to one side for a moment, please, and go back to the core bundle. And if one goes to paragraph 1 of the appellant skeleton argument, the second sentence begins, the key question in this appeal is whether when the couple stayed at that house, so this is the home in Almeria which is being referred to, because they considered that sunlight alleviated NJ's symptoms of obsessive compulsive disorder, NJ satisfied the requirements of Regulation 153. And I say that is not correct. The key question for this court, as I've already said, is whether the first-tier tribunal was entitled to come to the conclusion it did. And what we say the Secretary of State goes on to do, if we're going to go over the page to paragraph 3, is in essence to argue for at least one finding of fact, which I will come to, in relation to the decision about the sole or other reason for absence, was wrong in the sense it's used in the civil procedure rules, and not perverse in the sense it must be on an appeal to this court. The reason I say that, if I may, going to Judge Williams's decision, can be seen at paragraph 21. That is at page, I hope, 146 of the call bundle. Paragraph 21, it is apparent, reflects the nature of the submission made by the Secretary of State in the first-tier tribunal, to which I've taken in broad terms what the court can see from the written submission. And what Judge Williams does is to, first of all, accept the legal submission, which is means solely, and is not in dispute, and hasn't been in dispute at any point in this case. What Judge Williams says about halfway down that paragraph, the sentence beginning, "rather it must surely be read," that medical treatment must be the sole reason for the absence. And that is, I say, a key finding, because that doesn't say the sole reason for an extended versus a short absence. It says the absence. This is one of the reasons I say that perhaps the focus the Secretary of State has placed on this extended versus short point doesn't perhaps carry the weight that is being
You say
said.
that's the self-direction, and it's absolutely right.
I do. It says that the sole reason must be for medical treatment. There's, forgive me, I don't remember the citation, but the English and Emery Reinbold cases are quite clear that, particularly in cases such as this, the phrase used by the Court of Appeal was not to subject tribunal decisions to an overly pernickety critique. And it's the same in all levels of the court system. But if what we are searching for is what is the reason why Judge Williams reached the conclusion that they did, I say it is there. That is the direction which was made. The medical treatment must be the sole reason for the absence. And that is the finding which is then made immediately afterwards within the same paragraph. That takes me to some extent to one of the final submissions my learned friend made orally, which is the point made in paragraph 4 of the Secretary of State skeleton. That's back on page 22 of the call bundle. I'm sorry to jump around. And what we say is this is amounting to effectively an extraordinary submission that the Secretary of State is making in paragraph 4 of the skeleton, which is that the effect of the Upper Tribunal's decision is to create unfairness between claimants. And that is, we say, an unspoken presumption behind all of the submissions which are being made. And indeed, it came out orally at the end of my learned friend's submissions. The suggestion that a particular person in this case the claimant who has a doctor can give better evidence, which is what we say this submission amounts to. A doctor can give better evidence of, first of all, the effect of this treatment, because the effect of the treatment was in issue in the first-tier tribunal, but also what he did and what supervision he gave, which I will come back to, and that in some way this ability to give better evidence of what the purpose of an absence was, why a person left, and what happened while they were there, creates an incoherent scheme, is in my submission entirely unjustified by the wording of the regulations. The wording of the regulations is, we say, as my learned friend will deal with in a moment, a relief from a strict rule. That strict rule requires you to meet conditions, we accept that, but the conditions are absent for reasons in connection with medical treatment as defined. And as defined is important because the Secretary of State's submissions only very briefly touch upon that, both in the skeleton and as you've heard today. But medical treatment is the beginning of this case and not the end, we say.
I think the only point on unfairness being made there, as I've understood it, is that if she hadn't happened to be married to a doctor or a retired doctor or whatever, the argument would not have got off the ground. She was married to somebody who was an accountant.
Well, the point might equally be was, if you had a friend who was a doctor and came with you, that friend wouldn't
maybe
work.
the argument with the point is the happenstance of having somebody to come with you who happens to be a doctor.
That does happen often, though. Facts happen, and there indeed one of the points made in the KK case, which you were taken to, and indeed it might be worth me going there now to make the point. It's 236 of the authorities
I
bundle.
don't want to take you off track, so
No,
please
that's
don't let me deflect you.
No, that's all my. It's a very short point, so I'm very happy
So
to
where do
deal
you want
with
us to go?
it. 236 of the authorities bundle, please.
Which case was it?
That is the KK case.
Because we saw in the Cruz case, didn't we, the fact that the wife was a doctor didn't help much.
No, but it was also said to be irrelevant to the issue in that particular case because she was not giving the support required in that case for what was to be treatment. I appreciate that there's a disagreement between the parties to whether that was given in this case, but our submission is that's what the tribunal found. The point, if I can take the court to, is the quotation from Lord Justice Underhill at 148. It's in the judicial review case of Johnson, Secretary of State for Work and Pensions. And the court can see what Lord Justice Underhill says there.
148.
My lady, yes. The point in effect that Lord Justice Underhill is, I say, making in that quotation is Mr. Johnson in that case was seeking to judicially review one part of a social security scheme, and the decision was essentially, well, it may provide hard answers in some cases, sometimes very hard, as his lordship says, but that is not a good reason for departing from what are in essence clear words in a scheme. And my submission is this: the Secretary of State may not like the result it produces in this case, but that is not a reason to depart from the wording of the regulations, where, as we say, they do not admit of the difficulties which the Secretary of State says they do. So when I say there's in essence appeal to fairness, my point is that is bad for a claimant judicially reviewing part of the scheme for the same reason it is bad for the Secretary of State. If the wording of the scheme means what it says, and what we say it says, the fact they might not have intended that to be the result and don't like the result is not a good reason to say, well, we have to throw out this part of the scheme because it produces a bad result. And there is, I say, a degree of that position behind the entirety of the Secretary of State's case. So that's the first point. I say it's the search for an error of law, we say. I don't think that's particularly contentious. I can also very shortly, I hope, deal with what we say is the correct approach to statutory interpretation. Still within the authorities bundle, please. It's the Uber case, which is a tab 16. It begins at page 173. But if I can, I'm going to invite the court to page 190. It's 190. I'm sorry, Mother, I just didn't want to get ahead
me
of.
messing around with my bundle. I'm so sorry.
So page 100, this is an employment case, but I say this is a point which is of general practical and principal importance, not least because Lord Leggett, within the passage I'm about to take the court to, and cites a tax case and applies it in what I say should be the same application here. 68 and 69, the court has full reference, but I'm going to go to page 70, please. Sorry, paragraph 70, forgive me. On page 191, which is where his lordship says the modern approach to statutory interpretation is to have regard to the purpose and of purpose of a particular provision, forgive me, and to interpret its language so far as possible in the way which best gives effect to that purpose. The UBS and the Revenue and Customs Commission's case is cited, including the judgment of Lord Reed. And his lordship then goes on to say that if, for example, a fact is of no relevance to the application of the statute construed in the light of its purpose, it can be disregarded. Lord Reed cited the pithy statement of Ribeiro PJ in the Collector of Stamp Revenue and Arrowtown Assets Limited. Paragraph 53, the ultimate question is whether the relevant statutory provisions construed purposively were intended to apply to the transaction viewed realistically.
That's another old friend.
It is. And as in a moment, Mr. Hallstrom's going to, I hope, demonstrate the purpose of, first of all, the benefit in the first place, employment and support allowance, but also the statutory provisions dealing with presence in Great Britain. The purpose of those provisions is important. And as I said, relatively close to the start of my submissions, it is a relief from an otherwise strict rule, and the interpretation of Regulation 153 must be seen in that context.
Does that mean it should be construed restrictively?
No, indeed, quite the opposite, I say, my lady. If it is meant to give relief from a strict rule,
Right.
the starting rule is strict. If there's to be relief from it in the circumstances where, as Mr. Hallstrom will come on to say, it is for the relief of poverty that these provisions exist, it would be inconsistent with that purpose for there to be a strict interpretation of the exception to the strict rule.
I don't know that's right, because the strict rules in primary legislation and the relaxation is in secondary legislation. So the dominant purpose is exclusionary purpose in the primary legislation, isn't it?
Well, one of the, I don't make any criticism, my learned friend, for this. I think one of the provisions that was referred to, although you don't have it, was paragraph, I believe it's 6 of Schedule 2, which deals with also the vires for this provision, is at least as we say clear from the face of it. We will have to try and get it for you, I think, over the course of the short adjournment, at least as consistent with a non-strict application. It is paragraph 5 of Schedule 2. Regulations may make provision for the purposes of this part as the circumstances in which a person is to be treated as being or not being in Great Britain. So that doesn't suggest there is a strict rule which has very few exceptions.
The background is the provision of the primary legislation, which is an exclusionary rule.
Well, Yes, in short, my lady, but it does also depend how one looks at it, because if you look at section 1, it is a basic qualifying contribution condition. Sorry, I'm using some of the old phraseology. It's a basic qualifying condition to the entitlement to the benefit that you are in Great Britain. And this claimant was, at the start of her claim. There is a clear statutory purpose that people are not required for all purposes to remain in Great Britain to be entitled to the benefit. If there is no such strict requirement for all purposes, which one can see would be a very strict rule, and there must be exceptions to that, it is not, in my submission, consistent with a rule permitting exceptions that it must only be very strictly construed narrowly, because otherwise, if you have relief from a strict rule, what is the point of having exceptions if they are construed away so narrowly that in practical terms, there's never any benefit to a person who seeks to rely upon them, which is what we say the Secretary of State's position gives you in this case. You have very narrow, we say on their case, circumstances. We say they're wrong, but we also say on their case very narrow circumstances in which any person could ever seek to rely on 153 because of what they say the definition of medical treatment is. And in effect, as you heard from our learned friend's submissions, you have difficulties on difficulties on difficulties. That isn't a unique situation that this claimant would find herself in. One having to find their way into this provision for any claimant, it would seem, based on the way the Secretary of State submits this should be interpreted, becomes virtually impossible, because you have to have very specific kinds of treatment. You have to have a person, they say, who has a very specific qualification. You must be registered or licensed, words which don't appear in the statute anywhere. You have to have, they say, this treatment being carried out on you by this person, again, words that don't appear in the statute. But supervision by a person having these qualifications.
Statute, you mean the regulations?
Regulations, forgive me, my lady, yes. An enactment rather than statute. But we say this is indicative of the wrong approach. It's suggesting an exception that is virtually impossible for anyone to meet because of the standard of evidence or proof that might be required. And we say that is simply the wrong approach to this set of provisions.
But isn't that, taking the passage from Uber, which you just referred us to, if we're looking realistically at what is intended by this, what the regulations are surely designed to deal with are very narrow set of circumstances in which someone can be abroad for the purposes of treatment and still benefit from state benefits. Surely it is intended to be a narrow category or cohort of people.
One of the other purposes, my lord, which my learned friend took the court to Regulation 157 in terms of ways in which claimants can be sanctioned, is the terminology which is often used for not having complied with certain obligations, one of which is the claimant commitment and so forth. Regulation 157 places an obligation on claimants, as my learned friend quite correctly put it, to do things to try and alleviate the nature of their limited capability for work, which is one of the qualifying conditions for the benefit. If there is this power of sanction against a claimant for doing something which I don't think is disputed, objectively was intended, there's a dispute as to whether it's in part or solely, but I don't think there's any dispute, at least in part. The objective intention of the claimant was to try and relieve some of the parts of her qualification for the benefit. Is it right that she therefore be in the position that there is a strict rule against her for trying to, in effect, reduce the effect of her condition upon her? And in my submission, the answer to my lord's question is, well, no, that can't be the intention if you have other punitive provisions which say, in effect, you have to do things to reduce your disability if you can. And that is what this claimant was doing. That takes what I think would have been Mr. Hallstrom's submissions to begin, but it might perhaps, in view of the hour, be appropriate to break for short adjournment.
More or less.
More or less. Well, shall we, if that's a convenient moment at which to break, shall we do that and come back at 2 o'clock, please?
Thank
Thank you very much.
Court rise for you, board.
Am I right to assume you're going to kick us out?
Yeah, but I'll lock everything in so you can.
Really a quality tissue.
If you want, I can keep those.
Super drug. No, it's fine.
Because I have some more in my pocket.
I think